Okay, so good morning to everyone who is joining us this morning on this presentation on the stimulus bill and its role in the lives of many non-U.S. citizens. My name is Monica Crooms-McKeekian, and I am an immigration attorney at the U.S. Immigration Law Group in Santa Ana, California, here in Orange County. So our presentation is being recorded, and so it will be uploaded to our website, www.usilg.net, which is also going to be broadcasted on the last slide, and you'll be able to access this recording on our website. So I just want to make a disclaimer, which is the presentation that I'm giving today is not meant to be an exhaustive resource. There are probably going to be several issues that are not covered that many of you have questions about, but I do encourage you to email me. My email will also be included on the last slide, and I do encourage you to email me if you have questions that were not specifically covered today. And to the extent that I am able and qualified to answer those questions, I will do so. Otherwise, I will do my best to refer you to someone who is qualified to do so. So the information that I'm presenting today, I hope is comprehensive and able to answer most questions that people have regarding the impact payments and generally other issues that are covered in the CARES Act. And yeah, so with that, we'll get started. Okay, so on Friday, March 27th, President Trump announced the $2 trillion the $2 trillion coronavirus aid relief. Oh, I'm sorry, I'm having a small difficulty with my device here. Okay, sorry, here we go. So on Friday, March 27th, President Trump signed the $2 trillion Coronavirus Aid, Relief, and Economic Security Act, otherwise the CARES Act, or the stimulus bill. And really the objective of the CARES Act is to alleviate the economic impact of COVID-19. It's important for us to note that the stimulus bill assistance or these impact payments will not be issued to most non-U.S. citizens. So with that, we'll jump right into the impact payments. So the IRS began issuing impact payments on Wednesday, April 15th, to filers whose direct deposit information was already in their system. These payments are being issued to individuals who filed taxes in 2019, or if not, also in 2018. Or also to those who did not file taxes in 2018 or 2019 because their income was less than the amount that requires filing of income taxes. So if an individual did not earn enough that would require filing taxes, they can actually go ahead and log on to the irs.gov website, and under the Get My Payment tab, they can register their information so that they can also receive the impact payments. So there are a few requirements to be a recipient of an impact payment. So the financial requirement states that individual filers who have an adjusted gross income of up to $75,000, or folks who registered as head of household with a adjusted gross income of $112,000 will receive an individual payment of $1,200. Folks who are married and filed joint returns with adjusted gross income of less than $150,000 will receive an impact payment of $2,400. And any filer who has a child of, under 17, so a child 16 or younger, will also receive an addition of $500 payment per child. It's worth noting that the impact payment is going to be reduced by $5 for every $100 of adjusted gross income reported above that $75,000 amount for individuals, the $112,000 for heads of household, and the $150,000 for married joint filers. And then also individuals who have a adjusted gross income of $99,000 and heads of household with an adjusted gross income of $146,000 $1,500 will not receive payments, as well as married joint filers with an adjusted gross income of $198,000. So those folks essentially are not going to be deemed as individuals who may need that additional assistance. And then for anyone who is not sure where they can find the adjusted gross income amount, it's line 8B of your 2019 1040 form. Okay, and then also individuals who are receiving impact payments have to have a valid Social Security number. So this is not an individual taxpayer identification number or an ITIN. If you don't have a valid Social Security number, then you're not going to be receiving the impact payment. And then the other requirement is that the individuals are considered resident aliens as defined by the IRS. So you have to be a resident alien as defined by the IRS, have a valid Social Security number, and then meet one of these financial requirements. So let's get into who is deemed or who is considered a resident alien. And before I continue, I guess I should also say, if you have questions during this presentation, feel free, there should be a questions tab. Feel free to go ahead and input your question into that tab. And then at the end of the presentation, I'll go through and answer all those questions. But if you want, go ahead and just start typing them in now so that you don't forget the question and it's on our radar. Okay, so the impact payments being issued to resident aliens are folks who meet either the green card test or the substantial presence test. So we'll first take a look at the green card test. And so someone is a resident alien if they were a lawful permanent resident or also a conditional resident at any time during the calendar year. And so we're talking 2019. So anyone who had a lawful permanent residence or conditional residency in 2019 should meet the green card test unless they abandoned or renounced their lawful permanent resident status in writing, their lawful permanent resident status was administratively terminated by the Department of Homeland Security, or their lawful permanent resident status was judicially terminated by a judge. So if you were a green card holder or someone in your family was a green card holder and either renounced or abandoned their lawful permanent resident status or their green card was administratively terminated by DHS, or a judge terminated that status, then they will not qualify under the green card test. And then the other test for determining whether or not someone is a resident alien for purposes of the impact payment is called the substantial presence test. So for individuals with authorized stay who are physically present in the U.S. so it's 183 days during the 3-year period, including 2017 to 2019. There is a calculation that determines whether or not the person meets those 183 days. So it's not just straightforward the amount of time they were in the country or the number of days they were in the country would constitute or would equate to meeting that 183-day benchmark. There's actually a calculation that's made, and I didn't put the calculation in this presentation, but if anyone has doubts about it, they should email me because it's kind of complex, but I'll describe it in summary. And so you have to have in the current year at least 31 days. And then in the second year preceding the current year, 1/3 of those days let me try that again. So for the current year, let's do an example. So if in 2019, somebody had 120 days of presence, then in 2018, the number of days that would be calculated or counted would be 1/3 of the 120 days. Okay, so then we're talking 40 days. So then 40 plus 120, we get to 160. And then for the 2017 year, it would be 1/6. And so then that would be 30 days. So we're talking about in total, they would not meet that calculation because 120 plus 40 at 160 plus the additional 20 days for year 2017 would only reach 180. So it's a strange calculation, and I've probably already confused all of you, and I don't want to continue to confuse you. So what I'll say is, if there's any doubt as to whether or not someone meets the substantial presence test based on the number of days present, go ahead and just send me an email and we can work through it. And then also important to note is that some visa categories are going to be excluded from meeting these tests or this substantial presence test. So for example, individuals who are employees of diplomats under A3 or G5 categories will not be included in the impact payments. Students under F visas or M visas will not be included, and then exchange visitors under the J and Q visa programs also will be excluded. And then some professional athletes who are in the United States temporarily are also going to be excluded. Okay, now continuing on with who does not qualify for the impact payments, it's quite a few people. So individuals who filed taxes using the individual taxpayer identification number, we know are not eligible for impact payments. And eligible filers who also filed, say, joint returns with spouses who have ITIN numbers, unfortunately, are also going to be disqualified. So I'll repeat that. So someone who is eligible for the impact payment, who would otherwise be eligible for the impact payment. So let's say, for example, a United States citizen, and they filed a joint tax return with their spouse who does not have a social security number, who in fact has an ITIN number, perhaps because they are undocumented. Then that U.S. citizen joint filer will not be receiving the impact payment. Okay, and that's also true if they claimed any dependents on that tax return who did not have a valid social security number and who had an ITIN number. So unfortunately, several folks who would otherwise qualify for the impact payment, but because they filed a joint return with someone who does not qualify, then as a household will be disqualified. There will be exceptions for certain children who are adopted, or families who have adopted children, as well as military families. And then individuals who are being claimed as dependents, so maybe they're being claimed by their parents, will not qualify regardless of having a valid social security number or regardless of being deemed resident aliens or if they're US citizens. If you're being claimed as a dependent on anyone's income taxes, then you will not receive an impact payment. There is a loophole to what I mentioned earlier about eligible individuals who are filing taxes or who have members of their household who do not have valid social security numbers. So in the event that someone, we'll just use the example again of a United States citizen. So if a US citizen files taxes, but they file as married but separate, so meaning that on their tax return, they do not include their spouse and child because perhaps the spouse filed also married but separate, a separate tax return, then that individual who does qualify, the US citizen in this case, will get the benefit. So really the important issue is whether or not the taxes were filed as joint tax returns or separate tax returns. If the taxes were filed as married but separate, then the person who is eligible for the impact payment will receive those benefits, and then the person who filed as joint and married will not, which is not fair. I know many of you feel that it's not fair. Many of our clients call our office and are feeling outraged about this issue, but unfortunately, this was written into the bill this way, and so there's not really a way around it. And then again, individuals who do not have green cards and who do not satisfy the substantial presence test will not receive impact payments. Okay, so the IRS website has several details about the impact payments and how to register for them. I personally have visited the IRS website several times to try and access these tabs and information. There are lags because presumably several people are registering or trying to register, trying to find the status of their payment. So if you are kicked off, if you attempt to log in too many times in a single day, then you'll be frozen or locked out for a 24-hour period, which I learned yesterday. But so just know that there is heavy traffic on the IRS website, but that is the only way to register your information if you, or check your status if you qualify and you want to make sure that you receive the impact payments. Let's see, so, and then just to reiterate, so the IRS is basing the impact payments on the 2019 tax return, but if you have not filed your 2019 taxes, then they will use your 2018 tax return. And then if you did not file either year because you did not make enough, you did not have enough income to be required to file, then you can go ahead and register as a non-filer so that you can receive your benefit. And then also, it's important for everyone to know that income taxes will not be paid on the impact payment. So if you receive this amount, you're not going to be taxed on it. And then individuals who receive the amount who are prospectively going to be applying for a lawful permanent residency or U.S. citizenship in the future will also not be penalized for receiving this benefit. It will not be used in the public charge assessment for individuals applying for green cards. And then we know that in California on Wednesday, April 15th, Governor Gavin Newsom announced that a stimulus package aimed at providing aid to California's undocumented residents, individuals who make up 10% of the state's workforce, and who in 2019 paid more than $2.5 billion in taxes, are going to receive a one-time payment of $500 or up to $1,000 under this relief proposal. We don't have information as of yet as to when that money will be issued or how one can apply for it. Presumably these applications will be open in May. And also the state funds are likely going to be dispersed through regional nonprofits so that personal information from undocumented workers is not required to be provided. But again, this is not something that has been, this information is not that has been published anywhere I guess regulations have not been published regarding this stimulus specific to the state of California. These facts or this information that I'm providing is just based on what's been announced by the governor and what's been announced in various news sources. But the details are not yet available. But as soon as we have those details, we will go ahead and provide that information to our clients or to anyone who participated in this webinar in any way that we can, so that that information is updated and available. Okay, and so beyond the stimulus or the impact payments that are being offered by the stimulus bill, there has been a proposed expansion in unemployment assistance at the federal level. However, those who are applying for unemployment benefits, whether they be state funds or federal funds, have to do so through the state unemployment portal. So let's jump into this. So the Pandemic Unemployment Assistance Program, or the PUA program, is going to help individuals who are business owners, self-employed, independent contractors, those who have a limited work history, and others who are not otherwise usually eligible for regular state unemployment benefits to apply for those benefits if they're out of business or services are significantly reduced as a direct result of the pandemic. So eligibility for unemployment benefits requires that anyone who is a non-citizen or a non-resident have valid work authorization as issued by the Department of Homeland Security. So what that means is that the person who is applying for unemployment assistance through the PUA program, through their state portal, has to be able to establish or show that when they are applying for and receiving the benefits, so during the benefits period, which would be now that they're not working, they have a valid work authorization. And also that at the time that they were working to accumulate the credits to request this unemployment, so during the base period, they also had valid work authorization. So valid work authorization is a condition for being able to seek this unemployment. Okay, so who is authorized for pandemic unemployment assistance? So individuals admitted for lawful permanent residence, so green card holders, individuals lawfully present for purposes of performing services, and individuals who are permanently residing in the U.S. under color of law. So those two classifications really are dependent on the state in which someone is living. So for example, in California, we have individuals who do not have a green card, but are here with permission otherwise are generally deemed permanently residing in the United States under color of law. So PRU-CAL is basically the term that's probably most familiar to most folks. And so under these two programs, these include individuals with valid work permits through adjustment of status applications, asylum applications, DACA, TPS, VAWA applications if they have a prima facie finding, and then those who are applying for suspension of deportation and cancellation of removal. There are other groups that are also included, but these are the most common. And then also individuals who are under a program in which ICE has exercised prosecutorial discretion, and they've been able to apply for employment authorization through that program. So in California, we know that individuals can receive benefits that range from $40 to $450 per week through the state program, through state funds. But now there's going to be an additional $600 available in federal unemployment benefit funds. And the number of weeks that one can potentially receive these benefit payments are going to range from 13 to 26 weeks. And that's if you're paid at your full weekly benefit amount for each of those weeks. The $600 in federal unemployment benefits will be issued retroactively to March 29th and will end on July 25th. But again, just to revisit the eligibility, individuals who are not lawful permanent residents and not U.S. citizens, right, must be able to establish that at the time they are requesting the benefits, they will have work authorization through that entire benefits period, and that they were authorized to perform or authorized to work during the base period, which was the time that they were working to accumulate the credits to request unemployment. So work authorization is key. And so the Department of Labor website we have here provides information, more general information about the unemployment insurance under the CARES Act. But on that website, they do direct you to your state portal. And in California, it's the State of California Employment Development Department, the EDD website, and that is where anyone can apply for unemployment. I'm aware, it's not lost on me that the volume of applicants is so high that these websites are struggling to process applications and there are delays. So one thing that we've been recommending and just based on word of mouth is that people apply like in the middle of the night is a good time because the traffic is substantially less on those websites. So at odd hours, you may have a better chance at success in submitting an application. It's unfortunate that that is the case, but that's essentially all we can offer in terms of a solution to being able to get an application process when the website is faltering. Okay. And then a hot topic in the last year and a half has been public charge. We won't get into the details of public charge in much depth in this webinar, just because we do have a webinar that's been recorded and is on our website that discusses public charge in great detail. And so I will refer you to our website and to the resources tab where you can find that webinar. But I will say, with respect to the CARES Act and benefits under the CARES Act, we know that the impact payments are not going to be classified or are not classified as public benefits. And so they cannot be used to determine whether or not an individual is likely to become a public charge. And then also, the impact payments are classified as tax credits. And under the Department of Homeland Security's final rule, tax credits cannot be used to assess public charge. So if someone receives an impact payment because they are eligible for that payment, or they qualified, they should not be concerned that that will be used against them at the time that they're seeking a green card. If they're applying for lawful permanent residency, the receipt of that impact payment should not contribute to a finding of public charge. And then also COVID-19 testing generally. So we know that USCIS has indicated that people who seek testing will not be considered to have received medical treatment at the government's expense. So essentially anyone who seeks a test, anyone who goes to a testing center to inquire as to whether or not they have COVID, they're not going to be deemed to have received some kind of medical treatment at the government's expense. The stimulus bill, however, the stimulus bill does not give states the option to provide Medicaid to all individuals, regardless of status. So you can get tested. Then the question becomes, well, what happens if you get treated? And there's some ambiguity there. But what I can say is that in California, Governor Newsom, so in California, there's a little typo there, but excuse that typo. So Governor Newsom is mandating that the state's medical assistance program, otherwise known as Medi-Cal, cover care related to COVID-19 as an emergency service, regardless of the patient's coverage level or immigration documentation status. So I can't speak to all states, but what I can speak to is that in California, the governor is essentially authorizing Medi-Cal treatment or treatment through the Medi-Cal program for folks who are undocumented, and that care should constitute an emergency service that should not otherwise make them ineligible for residency if they were to apply for permanent residency as a public charge. So again, that's specific to California because that's where I practice, and that's where our office is located. I don't want to say that will be applicable across states, but we do know that there is some limitation as to whether or not a public charge assessment will include treatment for COVID-19. I would say that probably not, and regardless of whether it does, I mean, if someone needs medical treatment, they should not fear, or they should not be afraid to seek that medical treatment because of an impact on their immigration status. They should receive the treatment that they need, and then mitigate whatever immigration issues could arise in the future, with the assistance of an immigration attorney. But they should not abstain from treatment if it's necessary for their well-being, the well-being of their family members. It would just make no sense to do that. It's incredibly important that people seek the treatment that they need. But I can say that in California, Governor Newsom has mandated that Medi-Cal cover these COVID-19 related treatment options under the emergency service, so that they are not affected, or so that folks who are undocumented are not affected when they apply for residency, should the option arise in the future. Let's see. Okay, and then that essentially concludes the meat of the presentation. We're going to open it up to questions. I will say that we have published a resources guide at the end of the slideshow that lists all of the sources of the information presented. So we encourage you to read those articles should you have further questions that perhaps were not covered here. but I'm going to go ahead and open it up to questions. So feel free to type in your questions under the questions tab, and then we'll get started in answering them. Okay, so one question that I have is, does someone qualify for a stimulus relief if one of the two filing together is a permanent resident and the other one is a citizen? So they should, yes. If the applicants are filing jointly, or if the filers filed taxes jointly and one member of the household is a citizen, the other member of the household is a resident, assuming they both have a valid social security number, which they should, then they should both qualify to receive the impact payment. Now, the issue there may be if the household includes a dependent child on that tax return that does not have a valid social security number, but rather they have an ITIN number, then they will not qualify for the impact payment. So essentially, anyone who has included in their tax return a family member or a dependent who does not have a valid social security number, but rather has an ITIN number, will not receive that impact payment. Again, though, in the event that the family members, or excuse me, the household joint filers filed married but separately, then there may be the possibility that one of them does receive that impact payment. The next question is, do dreamers qualify for the stimulus since they have a social security number? And the answer to that is yes. So recipients of deferred action for childhood arrivals who have a valid social security number will receive impact payments. This is also the case for, again, we're going back to anyone who meets the substantial resident test and who is in one of the authorized programs for staying in the United States, they will receive that payment. Okay, and then the next question has to do with PRUCAL. So is it true that a person who has received PRUCAL can get a residency but can't become a U.S. citizen? That question, the answer to that question is if someone is receiving treatment or is receiving some benefit and they qualify through PRUCAL, they do actually qualify through PRUCAL, then they should be eligible to request their permanent resident status if they are otherwise eligible. And if they become a lawful permanent resident, then having received a benefit under any PRUCAL program will not disqualify them from becoming a citizen once they meet the requirements as a lawful permanent resident. So the answer to that is a person that has received benefits through PRUCAL, they should be able to become a green card holder if they qualify in under all of the regulations, and if they become a lawful permanent resident, assuming they meet all of the eligibility requirements to become a citizen, they should be able to become a citizen. I am aware I've had some clients who, I mean, honestly, through no fault of their own, just because they received some information that was not correct. They did receive benefits through a PRUCAL program, but they did not qualify initially. And so if that's the case, if someone has received benefits through a PRUCAL program that they did not actually qualify for, then my recommendation is going to be that that person definitely consult with an immigration attorney before submitting any application for benefits. And honestly, at this time, just given how new the public charge test that is now being implemented is, I would advise that anyone who's seeking an immigration benefit or a lawful permanent residency consult with an immigration attorney just to make sure that they do satisfy all the criteria and that there's not some other basis that they may be ineligible based on. And then also because the test for public charge is just it's not super clear, and so there's quite a bit to be considered and to be weighed. And so I just think that the default for anyone who's seeking lawful permanent resident status who will be subject to a public charge test, go ahead and consult with an immigration attorney before doing so. The next question is, does someone qualify for the stimulus relief if one of the two filing to get, oh, sorry, we already did this one. Okay. Okay. The next question is, can DACA recipients receive a stimulus check if they filed their taxes, but their parents claimed them as dependents? However, the parents only have an ITIN and not a social security number. So that's sort of a two-part response. The first is, I mean, if anyone is claimed as a dependent, then they are not going to receive an impact payment because they are being deemed as a dependent. And then again, if in that case, because the parents have ITIN numbers and not social security numbers, then they will also not receive an impact payment. So unfortunately, in that household, it doesn't seem like anyone will be receiving an impact payment. Okay. Okay, so do dreamers qualify since they have a social security number? Again, the answer to that is yes. Okay, oh no, I see that some people were not able to hear the presentation, and I hope that they were able to log onto the audio. In the event that the audio didn't work on your GoToWebinar, again, this is being recorded, and so anyone who was registered is going to have access to the recording, and then also we will be publishing this on our website. And so I'm so sorry for anyone who wasn't able to access the audio, but we will do our best to disseminate the presentation and the information so that you can hear everything that was presented today. Okay. So this question, the next question is, if a U.S. citizen filed jointly with a non-eligible spouse in 2018 and has not yet filed in 2019, if they file 2019 taxes now as married but separate, will they be eligible, or is it too late for that? So I believe my understanding of how the filing or the taxes are being considered is if you file the 2019 taxes now, because on the irs.gov website it does indicate that if you file your taxes as soon as possible, then you will be considered for 2019. So I think that if you file 2019 as married but separate now, then you should be considered for the impact payment. The impact payment should be issued to the person who is eligible, regardless of the status of their spouse, so long as the income taxes are being filed married but separate. Okay, it says, can students file as non-filers? And it depends. So again, they have to be eligible either as U.S. citizens, as lawful permanent residents, or they meet what the criteria under the substantial presence test. They have to have a valid social security number, and they cannot be included as dependents on their parents' taxes. So if all of those requirements are met, then the answer is the student should be able to receive an impact payment as a non-filer, but they will have to go to the IRS website and then fill out the information under the non-filer tab. Okay, so the next question is, if we have an installment payment arrangement with the IRS, will we be receiving benefits? So long as someone meets all of the requirements for the impact payment, then the IRS will issue it. So like, for example, I saw some instances in which someone was having their wages garnished because they they had basically money due to the IRS that they weren't paying, so the IRS was garnishing their wages. So the impact payment is not going to be offset by that. So the answer to the question is, if someone is in an installment payment plan with the IRS, the IRS is not going to hold that against them. If they qualify for the impact payment, then it should be issued. Again, the impact payments are being issued firstly to the individuals who have their direct deposit information already registered with the IRS. Those who do not have their bank account information or direct deposit information on file with the IRS should expect to receive physical checks in the mail. And so I would caution everyone to monitor the status of those checks on the IRS website. I will say that, and just as an anecdote, because it's relevant to this information, to this presentation, I do not have my direct deposit information registered with the IRS, so I have not received any kind of impact statement. I expect that I may receive a check, but when I try to log into the status tracker, the result that I got was that the information that I provided did not allow the IRS, or did not permit the IRS to determine the status of my impact check. So I don't know what that means, and so I guess the solution that I'm going to sort of resort to is just to wait and see. But yeah, so if someone is having wages garnished, or if someone is on a payment plan with the IRS, this should not affect their impact payment if they are otherwise eligible. Okay, so this question is, so California corporations and the owners of corporations who are not U.S. citizens or residents, lawful permanent residents, whether or not they can apply for the SBA loan for payroll protection. I'm hesitant to answer that question generally on this platform, just because I think that the experts who are better equipped to answer that question are the lenders. But what I would suggest is that you or the person who asked this question, go ahead and email me. Let me actually move the PowerPoint presentation along so that you have my information. So at this point, the screen, or excuse me, the slide that you should see on your screen contains my direct email. I would recommend that you email me, and also, if possible, to contact the banker or the bank that your corporation works with to inquire as to whether or not you could apply. My understanding is that my understanding is that the funds that are available through the payroll protection program have already been exhausted. So if someone applies at this time, I don't know that they would be considered for funds, but if they had previously submitted an application, then definitely I would say to contact the lender that they applied through to inquire as to whether or not their status will prevent them from being considered for that funding or the dispersal of those funds. Okay, I'm gonna try to get through as many questions as I can. There are some that are very highly specific that I'm hesitant to answer just for practical purposes, but if I don't get to your question during the presentation, please email me. Please send me an email and I will do my best to get you the information that you need. Don't be discouraged. But I want to try to answer questions that are more general that may be applicable to the greater group of participants. And then, okay, and then again, anyone who is considering applying for a green card, if you receive an impact payment, or if you receive unemployment benefits through the CARES Act, it's not going to be held against you for purposes of your green card application, and it's not going to be used in the assessment of public charge. Okay, and so my understanding is that so the question is, if a couple who is retired is receiving Social Security and has not filed taxes because they are not required to, my understanding is that yes, they will also be receiving impact payments. So if you have not received that impact payment yet, because your direct deposit information is not on file with the IRS, then you should expect to receive a check. And you know, I would say that at this time, it's more important than ever to make sure that you're very closely monitoring your mail, just because, you know, in situations in which there are programs in which widespread checks are being delivered, I anticipate that people will be peeking in others' mailboxes. So make sure that you're closely monitoring your mail and you're not leaving mail unattended if it's not locked. Okay, so again, any student who is being claimed as a dependent on their parents' taxes are not going to receive impact payments. Okay. So the next question is, what happens in a joint household in which a U.S. citizen spouse has a Social Security number from an old F1 status when the U.S. citizen and the spouse live outside of the United States and don't meet the substantial presence? So if there is a U.S. citizen who has a valid Social Security number, who is living abroad, and so this is actually quite a technical question. What I can say generally is that individuals who are U.S. citizens who are living abroad, who have valid Social Security numbers, and who have registered income taxes in either 2018 or 2019 are eligible for the impact payment, regardless of whether or not they're living in the United States. Now, if they're married, and so I have to follow up. I'm not actually sure what happens in the event that they have a household that contains, you know, a spouse who is not valid under the program. I'm not totally sure, and I don't want to answer this question incorrectly. And so my recommendation is that whoever posed this question to please email me, and I will look into this information. I'm not totally sure. I'm not sure. I think possibly they may not qualify if they've included their spouse on their taxes using an ITIN. However, if their spouse was not included, and they filed maybe married but separate or under some other, you know, categorization, then perhaps, but I'm not sure of the answer, and so I don't want to answer incorrectly. So please email me, and I will look up the info. Okay, and then the question is, can someone who is applying, currently applying for lawful permanent residence, qualify for the relief? And my answer to that question depends on whether or not they meet the criteria as a resident alien. So if someone is applying for a lawful permanent resident status, but who, you know, last year did not meet any of the criteria for being deemed a resident alien, the answer is that they will not qualify for the impact payment, even if at this point their application for adjustment of status is pending and they have received work authorization and a Social Security number. If they don't have their green card, they're not going to meet the green card test. And if they don't meet the requirements under the substantial presence test, then they probably won't get the impact payment. Now, if they're applying for a green card, but they were previously in authorized stay under a visa, you know, one of the visas that are not excluded, then perhaps, yes, they may be eligible for an impact payment. Okay. So let's see, it says if someone were to receive benefits under the stimulus package in California as undocumented, is there a risk when you apply for residency? That is a very good question. That's something that I also would need to do more research on once the program begins. Without more details, it's hard for me to answer the question now. My assumption is it probably will not affect the person's application for residency because the funds that are being used to give those stimulus checks of $500 to $1,000 are or have been announced to be state funds as well as donations from various sources. So as long as these funds are not federal, then it should not, and I don't think that it will affect someone who's applying for permanent resident status. And my hope and assumption is that the governor and the state of California, will take this into consideration when issuing that relief aid. And so I'm assuming at this point that it will probably not affect someone when they apply for their lawful permanent residency, just because the source of funds is not going to be federal. It's going to be exclusively state funds. Okay. Let's see. And then the next question, which is a good question, is the stimulus check a one-time payment? And the answer is yes. At this point, the stimulus check is under the CARES Act, under HR, I should know this off the top of my head, but of course I've forgotten. But yes, so the stimulus check under the CARES Act at this point is a one-time payment. Now, if there's future relief that's going to be distributed, then that likely will be under a different bill, but under HR 748, it's a one-time payment. Okay. Okay. So I think that's it for now. If I didn't answer your question, that's all we have time for at this point. If I did not answer your question during the presentation, please email me again. I'm going to do my best to respond to everyone if I'm qualified to respond. If the questions are more specific and it would just not be responsible for me to provide the information, then I will refer you to someone who is qualified to answer your questions, because at this point, the goal of U.S. Immigration Law Group is to disseminate information so that during this very uncertain and stressful time, people can find some comfort and some answers and just some peace, and know that they should not be penalized for taking advantage of the benefits under the CARES Act as long as they qualify. So thank you again to everyone who participated today with us. Again, my email address is being broadcasted on the current slide, and this information and this presentation will be published on our website, or it will be uploaded to our website, and you can access it on the resources tab, as well as several other important webinars and broadcasts that have been provided by not only me, but also my partners, Lisa Ramirez and Monica Lukacek. Now, an important sort of last fact that I'd like to share is that this presentation was done today in English. We are working on translating all of our webinars into Spanish, because it is important that the majority of our clients and the just community members that we serve are able to understand and also benefit from the information that we are sharing. So please bear with us. Within the next 2 weeks or so, we are going to be working to translate our webinars into Spanish so that you can also direct any Spanish-speaking relatives and friends, colleagues to our website to access this information in Spanish. And so with that, I thank you again, and I hope that everyone is doing their best to stay safe under their circumstances. And yes, thank you. Bye.